Rule 22 allows a person who owns property to effectively sue two or more parties that have claims on that property. The purpose is to prevent the property holder from having to go through multiple lawsuits and the possibility of inconsistent liability, such as being required to give the entire value of the property to two litigants, which would require that he pay out 200% of what he actually owes. The property owner in an interpleader action is known as a stakeholder, and the parties with claims on that property are called claimants. The stakeholder can be a plaintiff. He can do the interpleader via a complaint and serve the complaint just as any other complaint on all of the defendants, that is, all of the claimants. The stakeholder can also be a defendant. Upon being served by one claimant, the plaintiff in this case, the defendant can use interpleader to get all of the other possible claimants into the same lawsuit. If the stakeholder knows that the entire value of his property is going to be paid out, but not more than the value of his property, he has no interest in the case. You could care less which of the claimants wins the payout, as long as the dispute is resolved in a single litigation, and all that he owes is 100% of what he owes. Thus, once the interpleader is in place and all the potential claimants are brought into the action, he has no incentive to spend any time or resources on the case. He's completely disinterested in the case and is called, not surprisingly, a disinterested stakeholder. The disinterested stakeholder gives his property to the court and says, "Here, you take care of it," and takes no further substantive role in the litigation. The other parties, the claimants, fight it out. An interested stakeholder, on the other hand, is one who has a claim on the property or any portion of it. He has a financial interest. He will typically also give the property to the court, although sometimes doesn't have to, but remains a full-fledged litigant in the case. All of the rules that we've discussed until now, complaint, service, motion to dismiss, and answer, are all in place, but have some modifications, as we'll discuss here. If the stakeholder is a plaintiff, he files the complaint as normal, as we said, against all claimants. In addition to alleging the facts that he needs to in any complaint, all the substantive claims and all of their elements, he also has to allege facts related to the elements of interpleader. So you have to know what those are. And the elements of interpleader are: 1, the disputed property is identifiable. We know exactly what is in dispute. 2, there are two or more independent claimants. If there's just one claimant, or the two claimants are dependent on each other in some way, then you can't use interpleader. 3, there are or may be adverse independent claims in the property, which means that more than one person wants the whole thing, or all of the claims together add up to more than 100% of the property, which means that the plaintiff or the stakeholder, is going to have to pay out more than he owes. 4, the stakeholder reasonably fears multiple liability, closely related to the first thing, to number 3, I should say. And number 5, the stakeholder filed the interpleader action timely after receiving notice of multiple claims on the property. Basically, shortly after he finds out, he seeks to have interpleader put into place. Let's go over those again quickly. 1, the disputed property is identifiable. 2, there are two or more independent claimants. 3, there are or may be adverse independent claims in the property. 4, the stakeholder fears multiple liability. And 5, the stakeholder filed the interpleader action timely upon receiving notice of multiple claims. If the stakeholder is a defendant, he files a counterclaim against the plaintiff and shows that the 5 elements of interpleader are satisfied. He then uses joinder, using the typical rules of joinder, to get the other claimants into the suit. The claimant that wants to destroy the interpleader action must do so in his answer or in his answer to the counterclaim by showing that the stakeholder fails to meet any one of the requirements for interpleader. Those are the 5 elements that we discussed before. He has to poke holes in those claims. While there are some exceptions, the stakeholder typically must demonstrate that the court has either diversity jurisdiction or arising under jurisdiction, and that the court is a proper venue. Diversity is satisfied by looking at the citizenship of the claimants at the time the interpleader action is filed. Sometimes an interpleader statute will be available, and that's going to change the jurisdictional rules. If you are told that the statute is applicable, 3 things change in particular. 1, you no longer need complete diversity. All you need to show is that 2 of the claimants are from different states, and that satisfies minimal diversity for the purposes of this statute. 2, the minimum amount in controversy is $500. That's a very significant drop from $75,001. You now only need $500 in controversy. And 3, service of process is done by U.S. Marshals. If you want to see the statutes, they're 28 U.S.C. 1335 and 28 U.S.C. 2361. Arising under jurisdiction in interpleader cases typically requires a federal statute relating directly to the particular facts of the dispute, and therefore not likely to show up on your exam.